We are about to see what Fani Willis has to say about the defendant's motions to disqualify lead prosecutors Love and Hylton. This had come in yesterday, and I think I had seen it from Mel. I'm not a lawyer, but Thugger Daily also just shared it, and I also saw someone commented that Infamous Sylvia had it, so I'm going to link all of them in the description as well. What does this say, though? The state of Georgia, by and through Fani T. Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in opposition to Defendant Jeffrey Williams' motions to disqualify lead prosecutors, Chief Deputy District Attorney Adrian Love, which we're going to see abbreviated to CDDA, and Deputy District Attorney Simone Hylton. We're going to see that abbreviated as DDA. Filed on July 10th, 2024, and on July 18th, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendant cites no facts and no law that authorize this honorable court to disqualify either CDDA, Love, or DDA Hylton. Accordingly, the state respectfully moves this honorable court to deny defendant's motions to disqualify the lead prosecutors. In support of this response in opposition to defendant's motion to disqualify, the state shows this honorable court the following. So, what's the first thing? Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to defendant, the laws of Georgia and the facts of this case mandate this court's denial of defendant's motions to disqualify. In support of his motions to disqualify the lead prosecutors, defendant asserts that lawyer Love and lawyer Hylton, so this is a quote, so we're seeing it with the lowercase lawyer, have made themselves critical witnesses in this case. When Love engaged in text messages with a witness, and when Love and Hylton participated in a hearing in chambers, not an ex parte, but a hearing in chambers, with a witness and his lawyer, regarding contempt proceedings against a witness, defendant cites no legal authority in support of his position. Defendant, however, bears the heavy burden of proving that disqualification of the lead prosecutors in this case is warranted. And here we're getting a citation to Lewis v. State, instructing that it is the burden of the party seeking to disqualify counsel to prove the extraordinary remedy of disqualification is warranted. Interestingly enough, it seems like Fani Willis would be familiar with case law regarding burden for disqualification. It goes on to read, defendant does not even attempt to meet this burden. Instead, he rests his pleadings on legally and factually unsupported assertions. So what are we going to see? The argument here, and you tell me what you think. And you can play devil's advocate too. If you want to give a reverse perspective, if you want to try to see it, let me know. But A, the hearing in chambers, the ex parte meeting, was proper. Defendant asserts without support that Love and Hylton are disqualified as prosecutors in this case because they attended a hearing in chambers that he believes himself entitled to have attended. Defendant argues that the lead prosecutors in attendance at the hearing are disqualified under Georgia Rule of Professional Conduct 3.7a from further prosecuting the case because defendant now needs to examine them about the hearing and what took place. Defendant's arguments are not grounded in law. The hearing in chambers was about an ongoing contempt proceeding against a witness who, upon motion of the state, had been compelled to testify but refused to do so. The hearing was proper. Now they're going to cite King v. State. And what is King v. State here? King v. State ruling where King had complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify in King's trial, and confirming the use and derivative use immunity that would apply to that compelled testimony. The hearing appears not to have been part of the proceedings against King. Now, we talked about this when we looked at Love's response, because this was also cited. There's a distinction here. A brief hearing outside the presence of King, the defendant. But what time did court actually start? How long was all of that stuff happening on the morning of June 10th? That's just one distinction. And the matter was regarding a request for an order to compel the witness to testify. And from that transcript, there are way more issues on the table that were discussed during that meeting than just a request for an order to compel a witness to testify. The Georgia Supreme Court pointedly recognized in King, under circumstances closely resembling those here, do they closely resemble those here? That while King might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order compelling the witness to testify in King's trial, or that would suggest that King's rights were the subject matter under consideration. Now, that was all underlined. On the contrary, the trial court was obliged to consider whether the testimony was, quote, necessary to the public interest, and we saw that verbiage used in Fani Willis's order, the use immunity order, a matter which King had no standing to address. Any alleged bias on the witness's part was the proper subject of cross-examination, not grounds for denying the state's request for the order. And then C. Mosher v. State, holding that the credibility of a witness ordered to testify is a jury question. And fair enough, right? In a bubble, this is fair enough. But the defense's arguments, Brian Steele's arguments, aren't just about credibility. There's an argument about coercion that would influence credibility. And that's a separate consideration than just credibility in and of itself. Maybe we'll see that addressed as we go on. Likewise, in Allen v. State, the Georgia Court of Appeals cited King in support of its holding that a defendant had no standing to contest the grant of use immunity to a witness. Under both King and Allen, the June 10, 2024, in-chambers hearing was proper, and defendant had no standing to contest the hearing or to participate in it. Surely defendant does not expect that a proper hearing, which he had no standing to contest or to participate in, now somehow provides defendant the right to disqualification of the lead prosecutors who took part in the hearing. Such a position makes no sense. B. Disqualification of the prosecutors would constitute an abuse of this honorable court's discretion, where other sources of evidence about what happened at the hearing are available to defendant and obviate any need of defendant for either prosecutor's testimony. So the transcript is there, you don't need anything else. I think that's what we're going to get. Even if the hearing had not been proper, an even bigger hurdle barring disqualification of the prosecutors is the availability to defendant of other sources of evidence of what happened during the hearing. With some exceptions, Rule 3.7a of the Rules of Professional Conduct of the State Bar of Georgia provides that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. However, the party moving for disqualification, so the defense here, Brian Steele, Jeffrey Williams, of a lawyer under Rule 3.7 has the burden of showing that the lawyer is likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact and that there is no other evidence available to prove these facts. The defendant cannot meet that burden. Why? Well, there's something else out here. The hearing in chambers was taken down by the court reporter and transcribed. All parties now have the transcript of the hearing in chambers. The transcript clearly identifies those who were present, and that includes sheriff deputies, investigators from the district attorney's office, the witness currently on the stand, and the witness's attorney. Indeed, defendant will get to cross-examine the witness at issue himself. The practice of trial attorneys testifying is not approved by the courts except where made necessary by the circumstances of the case. Timberlake v. State. The advocate as a witness poses innumerable threats to the integrity and reliability of the judicial process. Courts have properly refused to permit a prosecutor to be called as a defense witness unless there is a compelling need. Trial courts are generally held to have discretion on whether to allow a party to call opposing counsel as a witness, on the view that attempting to call opposing counsel to establish some fact that can be readily proved in a different manner should be discouraged. Do you think the transcript is enough to say that things that Brian Steele may want to know about is sufficient, that there's no need to call Love and or Hylton as a witness? Because we've seen several motions ask about possible other meetings. We've now seen in the motion officially specific lines called out where we think things are missing from the transcript. We looked at that yesterday over on Nick Staro's channel. But all that considered, there is a transcript and it's sworn to be a complete and accurate representation. So factually, as far as what the judge is supposed to consider, do you think that that's enough? There is no compelling need for the lead prosecutors to testify, especially given that there are ample other sources of information to establish what occurred at the hearing in chambers. C. Disqualification of prosecutor Love based on the exchange of text messages with the witness also would constitute an abuse of this honorable court's discretion, where other sources of evidence about the text messages are available to defendant and obviate any need, in quotes, by defendant of Love's testimony. And so we're going to talk about text messages and why it means Love's testimony isn't necessary. With ample sources of evidence about the text messages being available to defendant, most notably the witness herself, whom defendant already has examined at trial, defendant asserts that the text messages also require his examination of Love. The law contradicts defendant's assertion. So we have Schaff v. State, noting that speculation as to the content of an opposing counsel's testimony could not support a disqualification order. So speculation isn't enough. The Georgia Court of Appeals held in Schaff v. State that the trial court abused its discretion when it disqualified trial counsel on the basis that the trial counsel's testimony was necessary, where the victim made a statement in his presence, but the statement had also been overheard both by the victim's mother and by trial counsel's assistant, who could testify to the circumstances surrounding the child's statement. Although the Schaff court agreed with the trial court's concern that the trial counsel's testimony would be relevant to the jury for determining weight and credibility to assign the child's videotaped recantation, and possibly the preferred method, the Schaff court ultimately concluded that trial counsel's testimony was not necessary to prove any fact related to the video or the circumstances surrounding the video. Now, this seems like we have a bit of a distinction issue here. I would say if Miss Bennett felt uncomfortable by the investigator that was getting information from her, we don't just have an issue about the circumstance at question. We have a situation where now we have to consider what witness Miss Bennett was saying to the investigator and what she may have been comfortable saying about that investigator to Love when the investigator had been telling her he was the only person that she needed to speak with. But okay, that's just me. Let's keep going. In Clough v. Richello, this court explained that such speculation as to the content of an opposing counsel's testimony could not support a disqualification order. Otherwise, any party could successfully move to disqualify an opposing attorney by simply averring that the opposing attorney might possess information that is damaging to the attorney's client's case, and therefore, that the attorney is likely to be a necessary witness in the moving party's case. To approve of such a tactic would be opening the door to blatant misuse of a rule that already has great potential for abuse, emphasis added. Defendant proffers no information he seeks to gain from Love that he cannot quite readily get or has already gotten from another source. Interesting. Disqualification of the lead prosecutor under these circumstances would constitute an abuse of this honorable court's discretion. Defendant's reference to the former trial judge has no bearing on a defendant's motion to disqualify. Although it is not necessary for the present motion, Williams asserts that he wants to call as a witness the chief judge who, until recently, presided over the trial, so Glanville. The state submits the chief judge is not a necessary witness for the same reason the lead prosecutors are not necessary witnesses. Moreover, while at no point did the chief judge comment on the evidence before this jury, it appears defendant's primary purpose in calling the chief judge would be to ask him to do just that. Although defendant has not requested permission to do that yet, the state submits the court should deny such a request when and if it's made. But what's interesting, if we just think about that ex parte, that in-chambers hearing, we've got Glanville peeping out the door when Woody wasn't in the room yet. He was still outside with Hylton. So there are possibly things that Judge Glanville could know about that moment in time that we couldn't elicit from Love or Hylton. And then Fani overall is saying none of them should be called to talk about these things. And I'm not sure that saying there's no reason for this to come in because the judge didn't comment on this stuff in front of the jury. They were all present with one of the witnesses while he was sworn in. So they are, in effect, witness to what Kenneth Copeland was saying. And not all parties were present at all times during all of that happening. So I'm not sure I really get this argument. Maybe something's going over my head here. But anyway. 2. There is no evidence to authorize disqualification of the lead prosecutors under the two only generally recognized grounds for disqualification of a prosecutor in Georgia: conflict of interest and forensic misconduct. And defendant does not even purport to request relief on these grounds. But I don't know about all that because the Georgia Rules of Professional Conduct, special responsibilities of a prosecutor in a criminal case shall comply with Rule 4.2, and then also make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or that mitigates the offense. If there's prosecutorial misconduct and that's used as a reason to bar retrial and a mistrial is granted, then there isn't really a scenario where we're disqualifying a prosecution so a case can continue. So we're going to get some citation of case law here, but just keep that in mind. So defendant does not allege, nor does there exist evidence in this case, suggesting that either prosecutor in this case should be disqualified under the two only generally, so not constrained absolutely, recognized grounds for disqualification of a prosecutor in Georgia. One, an actual conflict of interest exists, or two, a prosecutor has engaged in forensic misconduct. In McGlynn v. State, the Georgia Court of Appeals recognized that a trial court considering a defendant's motion to disqualify an elected district attorney or her staff based on alleged misconduct must hold those who allege such misconduct to a high standard of proof. Even assuming for the sake of argument that the allegations set forth in defendant's motions were true, those allegations failed to meet the high standard required to disqualify two lead prosecutors from an ongoing and well-advanced criminal case in the middle of trial. The extraordinary relief Defendant Williams seeks is simply unwarranted, and his motion should be denied without any further proceedings. And I do agree it is extraordinary relief, but I disagree that it's a simply unwarranted request. And there's a footnote here that additionally, the court should deny the defendant's motion as not being sufficiently particularized in violation of the court's standing scheduling order for criminal cases in Judge Whitaker's division. His motion does not specify with particularity any evidence that supports his desired relief. At best, the defendant has merely cobbled together a broad and barely defined class of allegations to support his theory, but he has utterly failed to explain how such allegations would necessitate or even authorize disqualification. So in other words, if Judge Whitaker doesn't like that and Judge Whitaker agrees that it's lacking particularity, could be an uh-oh. And then conclusion. For the reasons stated above, it would be an egregious abuse of this honorable court's discretion to disqualify Love and Hylton based solely on the de minimis assertions advanced in defendant's motion, especially where there is no evidence of any ground authorizing either prosecutor's disqualification. This court should not abuse its discretion by disqualifying the prosecutors, especially where the June 10th, 2024 hearing, about which defendants, underline bold, incessantly complains, they're just going on and complaining for nothing, because it was proper, in all caps, bold, and underline. And where there are available to defendant other sources of the information about which he claims to need to examine Love and Hylton at trial. Defendant's efforts to forestall the conclusion of the longest trial in Georgia's history, and then they cite a news article that says it's officially the longest, by seeking to disqualify the lead prosecutors should be immediately stopped. This honorable court should deny defendant's motions to disqualify the lead prosecutors in this case on the pleadings alone, so without a hearing. Respectfully submitted this 26th day of July 2024. Fani T. Willis. So there you go, you guys. That is Fani's response to the motion to disqualify Love and Hylton. So let me know what you think. Do you think that the defense can get everything they need from that transcript? Do you think that meeting was proper? Do you think Judge Whitaker should deny this on the pleading alone? What are your predictions for anything moving on from this point forward? There are some other motions, you guys. Again, this came from Mel. I'm not a lawyer, and she said that she didn't see the other ones publicly available yet, but maybe Monday, more mania, more filings, more document mania on Monday. Hope you guys are all having a good weekend. Take care until the next time we catch up. Bye-bye.